All rise. Florida Supreme Court is now in session. Please be seated.
Welcome back. Our next case is Universal Property and Casualty Insurance Company versus Hughes.
Thank you. May it please the court, Dinah Stein on behalf of the petitioner, Universal Property and Casualty Insurance Company. And of course, we're here on application of the Florida's pre-suit notice statute in property insurance cases. I want to start by saying there's no contractual right at issue in this case. And Menendez, the decision of this court that the 6th District below believed guided the result, dealt with a statute that required all PIP policies to have contractual provisions. Devon, the case that the 6th District also felt guided this result.
Those are two very interesting ways to phrase it. But before sort of breezing past the assumption of those two first sentences, was the 6th District Court correct that Menendez governs the outcome in this case, that Devon governs the outcome in this case?
No, Your Honor. We believe it was an over-application of Menendez and Devon. And I think that's a very important point because all of the conflict courts have felt constrained by Menendez. And I think the 6th District made clear it felt constrained. It might have reached a different result. Menendez, as we've said all along, was very specific in its application. It's been read too broadly.
Let's assume that I don't buy the distinctions between Menendez based on it being relevant to the PIP statute, that while the PIP statute is different, let's assume that I don't think it's distinguishable. Is your argument that Menendez and Devon don't apply because, well, Devon's not specific to PIP, but because of PIP, or are you just saying this isn't even a retroactivity question at all?
The latter, Your Honor, that this isn't even a retroactivity issue at all.
Can you say more about that?
Yes, Your Honor. And I'll go back to what's, I think, been swallowed up by application of Menendez and Devon, and that is there's a threshold inquiry when we're dealing with any retroactivity analysis. In fact, we don't just dive into dates. We decide what's the issue that's being addressed by the statute. Is it substantive or procedural? That's been the threshold analysis going back from the Lafayette, Smiley, Devon did that analysis as well. And so we don't just, now Menendez had a very broad statement that said if it's a action on an insurance contract, we look at the contract as the date. That's in the context, and if you read that line from Menendez, in the context of when the contract's at issue. If the legislation is impacting the rights and obligations under the contract, then Menendez applies. And the date goes back to the contract, and that's the legislation and the rights that we look at.
Can we back up? Can we back up for a second? Because you started off saying that there's a distinction between, it seems like one way of reading the cases is they assume this principle that the background insurance law becomes part of the contract, and that's the justification for why, when you're sort of trying to figure out, well, retroactive relative to what, you look at the date of the contract and you look at the law as it stood at that time. And it seems like the cases, sometimes the terms of the law are actually like written, physically embodied in the contract, but sometimes they're just sort of background law that is deemed to be kind of absorbed into the contract, even if it's not explicitly written out. And it sounded like you were trying to make a distinction between cases where the words from the contract itself sort of parrots the statute, but it's in the contract, versus the contract says what it says, and then you have the law kind of surrounding it, which is deemed part of it. It sounded to me like you were trying to draw a distinction between those two situations. Is that part of your argument, or do you accept that under our jurisprudence, whether it's written in the contract or whether it's just the law that's surrounding the contract, that the rationale is that at time one, when the policy is entered and the background law as it exists at that time, that's basically sort of the fixed point in reference to which we look at retroactivity, and then you ask the questions about substantive, procedural, et cetera. But that's kind of where that's kind of analytically where you're starting from.
Yes, Your Honor. In other words, if you take plaintiff's position to its logical extent, what they're saying is that once the policy issues and the insured makes their premium payment, the policy comes into effect, that the entire regulatory status quo just freezes in time.
Right,
no matter what.
Right, and so what I'm asking is are you saying that that's an incorrect reading of our precedent? And when you say freeze, I'm not saying to sort of get ahead and ask can it ever be changed, but in terms of for deciding sort of what is the benchmark against which we're measuring retroactivity and whether some things are procedural, substantive, whatever, do you dispute that premise that forms the baseline?
Yes, Your Honor. Okay,
and what case would you point to? Because it seems like that's a sort of a bedrock principle of our law. I mean, what case would you point to convince us that shouldn't be the baseline, kind of the substantive baseline?
Certainly, and what we're pointing to is really this court's jurisprudence on what is a substantive versus a procedural issue. I mean, there is a test for it no matter what case it is, and that is, does the legislation, let's say in this context, attach legal consequences to past events? So in other words, it's very clear under the law that just because a statute applies to events that have happened, it's not improperly retroactive. It actually has to attach legal consequences to those events such that someone is losing a right that they had, not just an expectation that the law will stay the same, but a right.
But
yes,
there is an
Honor.
expectation that the contractual rights are going to stay the same. Wouldn't you agree?
No question.
And so to the extent that we have this background principle that we we've been talking about this for a long time, and it is most often, as I understand it, seen it, most often talked about in the insurance context, although it is applied in other contractual contexts as well. That kind of the table is set based on the statutory background when the contract is entered. And so that when the contract is entered or when it is renewed, and obviously this all can change because contracts don't go on forever and they get renewed and then the new framework can apply. But when we're reading an insurance contract, we have to understand it in light of the law that was in effect when the contract was entered. That just seems like an elementary principle of our law, and that cuts both ways. That can be good for the insured, or it can be good for the insurer. And like on this issue, apparently insurers are arguing it one way when one position when it helps them, and the other position when that helps them. So all these things can cut both ways, and one person can be on the winning side based on the argument, and then the argument hurts them if the facts are different. So I'm struggling with how your position can be reconciled with this body of case law, where we understand these insurance contracts in light of the law that was in effect when they were entered.
And I'm to that point, I'd like to just distinguish these cases, the case below and all of the conflict cases on this statute. None of them talk about the policy. There's no discussion about the policy and what rights have been altered by the policy.
Well, that's because there really aren't any, right? I read the entire policy yesterday. And so there's nothing in the statute that directly affects something that is written in the policy. Would you agree with that? I mean, that's what you're arguing.
Yeah, absolutely. Yes. And really that goes to our point.
Right. And so you're using kind of this term, I think it's from Langhoff, a U.S. Supreme Court case, that the court asked whether the new provision attaches legal consequences to events completed before its enactment. And so you're saying it doesn't attach any new legal consequences to events completed because it doesn't affect anything that the parties entered into contractually.
That's exactly right. None have been pointed to. And if you look at cases like Menendez, Devin, and the Menendez conflict cases, Hassan, the other cases, they all talk about rights in the contract being incorporated into the contract. That is the difference between all of these cases regarding this statute, is there's a void of any...
Right. Yeah, Devon specifically, though, how do you square that argument with the language? I mean, the holding is that the district courts have to apply this test, and breaks it down. First, ascertain where it's tended to apply retroactively, and then second, if clearly expressed, determine whether retroactive application would violate any constitutional principle. So to the 6th District's defense, I see the Menendez argument that you're making, that PIP is expressly incorporated into the statute by virtue of statutory scheme. But Devon, in the property insurance context, can you explain to me how we can decide this case consistently with your argument without either receding from or modifying the rule in Devon?
Sorry, Your Honor.
Go ahead.
Absolutely. And so Devon, it's very important, started not just with the two-pronged test, but it first said the threshold issue, what are we talking about? Again, what is the right? Because that is the threshold test, is, are we talking about a substantive or procedural right? And said the right is the contract, because there's an appraisal provision in the contract which has been altered by the application of subsequent legislation. That's exactly why they started with the premise of it's substantive, it impairs contractual rights.
No, but that question, the substance or procedure goes to the content of the law, not the contract.
It goes,
I mean, whether it affects, how it affects the contract obviously is a question then for sort of the step 2, but I mean, it seems like the precedents say that when you're trying to answer this kind of substantive, is the new scheme, is the new law substantive or procedural, you're looking at what is in the law. That's kind of at step 1, because you're asking that question in terms of, from this perspective of, what does the legislature need to say as to whether it, and in this context, retroactive, I think under our case law, and it didn't have to be this way, I don't think, if we went back, but it just seems to us, to me at least, like for decades we've assumed that sort of the concept of retroactivity in this context refers to, changes to this, relationship between the policyholder and the insurer dating back to when the policy was issued. And so you're asking, so if that's sort of the time one, if that's the benchmark, then you're looking at the new law and you're saying, are these changes procedural or substantive in nature? Is that wrong?
no.
Okay.
No, Your Honor. That is our argument.
So that
Again,
involves looking at the law. That involves looking at what the law is doing.
And the test for substantive nature of the right that's allegedly being
Well, and that's
impacted.
kind of a step 2. That's a step 2. I would say that, and this is where I think that there, it seems like there maybe is some, I guess it's possible to read Menendez as implying that anything that is considered substantive is going to sort of fall at step 2, which that doesn't seem like that can be right. But it does seem like, for purposes of both what are we looking for from the legislature in terms of their expression of where they want it to apply, and just asking that question, that we do kind of look at the law itself to decide whether is this kind of a is this a procedural thing or is this a substantive thing, and then if it's substantive, then you've got to ask the step 2 questions of, okay, does it impair rights, et cetera, et cetera.
And
I think your argument might be stronger at step 2. It seems like it's pretty weak at step 1 because I think if you read all of these provisions together, I think clearly it's sort of a mix of substantive and process, but it does impose obligations on both sides that weren't there in the beginning, and you don't have any explicit expression from the legislature saying we want this new scheme to apply to contracts that were in effect as of whatever date, which seems like in the interest of the world, both, you know, from the legislatures at the drafting stage and policyholders and insurance companies, it seems like the system as a whole has a lot invested in clarity, you know, of the rule as to what's the language that we're looking for to sort of trigger all this analysis. And I don't see that in the statute.
And Your Honor, first of all, jumping to step 2, because that was one of our issues with the 6th district, is it did make a presumption that because it's substantive, which we disagree with, but it can't stand. That's not the test either. I mean, there still has to be a finding.
Right. So help us get to step 2, though, because that's all irrelevant if you fail at step 1.
Correct.
Okay.
And again, I'm going to go back to our issue with Menendez, because Menendez says we have to look at the statute as a whole. We contend that's never been the test for retroactivity. The only reason that the courts below and the conflict courts have applied that analysis is because of Menendez. And Menendez, you know, this was a legislative regulatory scheme that supplanted the common law. That is why this court never starts an opinion, and this was Menendez, by saying in order to get to the result, we have to look at the history and purpose of the statute, unless that's really important to its decision. And so in Menendez, the fact that the Florida drivers were trading their right to a common law cause of action for very specific regulatory scheme with swift and virtually automatic payment was critical to Menendez. And I say that because we're going back to, do we need to look at the whole statute? And I would submit, no. That's not how retroactivity has ever been analyzed outside
But I think the Chief asked you to focus on the clear statement rule. And that what we're talking about here? Are you talking about the clear statement rule?
I was talking about whether we have to. I was actually responding to Chief Justice's question regarding the fees.
I misunderstood.
Yeah.
But
I think what I take you to be saying is that you're saying that it's step 1 because the law is not part of the contract and because this is procedural. You're saying that there is no clear statement rule in this
There's
context.
a presumption that it applies. I mean, that's why we've started with this analysis, because going back to Smiley, Devin, there is a presumption.
For that to be true, we would have to agree with you that it's procedural.
Yes, Your Honor.
And in order to agree with you on that, do you agree that the only way that we could really call this procedural is by isolating the notice and looking at it? I mean, and this seems like that's your argument in your brief, is that we're not just detaching it from the attorney's fees thing. We're not just detaching it from what the insurance company has to do in response. You're also sort of you're treating, and I can't remember which court it was that, I think it was Scales in one of his opinions in the third. I mean, you're basically, you know, you're treating all of the things that the insured has to put in their notice as being totally procedural. I mean,
yes.
You want us to really just focus on, just view this as, hey, I just have to send you a notice saying that I'm about to initiate litigation, and then.
Yes,
right.
Your Honor, because there's, as long as there's a compliance with the notice procedure, the courthouse doors are open. It's not like, you know, other procedures where it's a key to the courthouse door and you have to do more than that.
What
it's
about
a procedural.
even with compliance with the notice, isn't there a difference in eligibility for pre-notice attorney's fees under this amended statute?
The doors, by the time you get to that part of the statute, the doors to the courthouse have been open. I mean, an attorney hasn't earned any fees.
Regardless, doors are open, yes. But how much fees can you recover? Can you recover? There is a difference in the statute, correct, on pre-notice attorney's fees?
Yes, Your Honor.
So if I operate off of your theory that we're looking at the conduct that's being regulated by the statute, what is your argument as to whether or not that specific change, and I understand look at notice in the vacuum, but assuming we're looking at the statute overall and how the notice operates with the attorney's fees provision, what is your argument as to when that conduct occurred? Is that conduct, if we're looking at whether the insurer acted reasonably, for example, is that conduct that would have occurred before the statute's enactment, or do you think this attorney's fees provision, even if it's a substantive change, all targets conduct that was after the statute's enactment?
And I think it's going to differ case by case, and I think that's also why that the courts were, for the most part, clear to say subsection 8, the former subsection 8, is not before us. I mean, even just Judge White in his concurrence here said...
Let's pretend it is before us, though.
That I understand is a separate issue that's going through the courts. I mean, it is...
But for purposes of answering the question in this oral argument setting, assuming that we are going to look at the statute as a whole, can you answer that question? I mean, what is the impact of the attorney's fees? Is it substantive or procedural? Does it impact any action that occurred prior to the statute? How do you fit the attorney's fees aspect into your overall argument?
No, clearly, attorney's fees are substantive. I mean, I think that's what the court has said repeatedly. I don't think any court has differed from that. The complexity of answering specifically whether the conduct applies is we don't know eventually how it's going to turn out as far as applicability with the appeal of Section 627-428. I'll agree with Your Honor that at the time this lawsuit was filed, subsection 8 was there. Fees are generally substantive. It's also essentially an advisory opinion as to how it would apply in this case. I mean, that's how the 3rd District in the Adju case dealt with the issue. And this may never be an issue in this case. That's why we're saying the fees provision can be detached from this analysis just to determine whether this pre-suit notice provision applies. And
so if you're looking at it from the legislature's perspective, do you think that they didn't, quote unquote, intend for the, so they know the background, we're supposed to assume they know the background law, so they're going to know that this attorney's fee thing is substantive, right? Do you view them as having wanted it to be retroactive and hoping that at step 2 we say that it's, important enough, or we do some balancing test, or we say that it doesn't violate a right? Or do you think that they kind of, even though they just had one effective date in the thing, that they were sort of thinking that the world and the courts were going to figure out, this part of it is prospective and this part of it is retroactive? I mean, how is that system, I guess before I get ahead of that, what do you, if you put yourself in the legislature's shoes, what did you think they were doing?
Well, I mean, the legislature had the option here, and in fact, the House bill did have very specific language to do what plaintiffs say it does, and that was omitted, and I do think that is still a consideration for this court. I mean, that's the Don King analysis.
Forget what they didn't do. Like, given what they did, what do you think that they want? Do you think that they viewed all of these things as applying to contracts that were entered, before the statute went into effect, or do you think that they expected the world to sort of cut and paste different parts of it and make some of it, quote unquote, retroactive and some of it not?
No, I think the legislature intended for the notice provision, which is procedural and has always been applied, whether or not the rest of the statute could be applied, to apply to all cases. The legislature said this applies to all suits. I mean, we've gone through the language.
But if you were drafting, wouldn't you know, if you knew the background law here, wouldn't you know that that the magic words are that you have to say which policies it applies to rather than the suits? Because I mean, isn't it, all of this is tied up in sort of what assumptions you make about sort of this, what is the sort of legal sort of status quo against which the legislature is legislating, right? And clearly, I mean, if you're gonna be a careful lawyer about this and you want it to apply to existing policies, you would say that. You wouldn't say all suits, because that that would still kind of leave this uncertainty as to, well, so what if it doesn't apply to the policies, right?
Well, right. The legislature had an opportunity to clarify, and it did in 2023, I believe, to go back to just the 2022 changes, which took out subsection 8 and chose not to clarify that point, even though, these cases have been out there.
Okay, why don't you take a minute and a half and then we'll hear from the other side, and you can have some time on rebuttal, but go ahead.
Thank you, Your Honor. I go back, though, to the premise of Lawnwood, for instance, in cases that have held for decades, that we look at whatever heart of the statute is before the court at the time to determine, does it apply? Is it substantive or procedural? I mean, that's, I think, where we really need or would ask for clarification on Menendez. Two parts of that, because I really think that it's been over applied here and is misguiding the analysis, and that is number one. Does Menendez mean that no matter what has been legislated since the contract, that you always go back to the date of the contract? We submit that when we get out of this regulatory scheme for PIP, that it should not be applied to things like property insurance, which are not heavily regulated with policies that are required by the legislature. So I think that's number one, is that Menendez needs clarification that we start each contract case with the threshold question: are we dealing with a substantive or procedural right? The second thing I think Menendez needs clarification of, that we would ask for, is, this concept that we have to look at the statute as a whole. And again, I think that goes back to Menendez's holding that we intended, or the legislature intended, for this swift and virtually automatic payment, which makes us look at how the rights that existed at the time of the contract changed. And I would submit that we look at, the courts look at whatever the provision is before them at the time, determine whether it's even substantive or procedural as the threshold issue, and if it's procedural, there's a presumption it applies. And then we don't have to get into the legislative intent.
On this, carving this up the way you want to carve it, I've just struggled to understand how that is really faithful to properly understanding what the legislature was actually doing here. They had, I think, an integrated scheme to achieve certain policy goals. And all these pieces fit together. And they get kind of the initial part of this is the notice, but then all these other things fall out from that, and it's all intertwined. And I don't see how, when we're looking at how this all works and how retroactivity works, it just seems to me to be highly problematic to kind of ignore that integrated scheme, which is the focus of what the legislature is doing. I just struggle with it.
And yes, Your Honor, and may I just respond to that? That goes exactly back to our issue with Menendez. Menendez says because it's an entire scheme that impacted the policy, you have to consider the legislation as a whole. This is a lawsuit statute. It's not a policy statute. And we submit this can be looked at in isolation without even looking at legislative intent and the intent of the statute, because if it is procedural, then we presume that the legislature intended it to apply absent policy language to the contrary.
You already acknowledged that in part of the quote-unquote integrated scheme includes at least one element that is undeniably substantive, i.e. the attorney's fees.
It did, yes, before those were repealed, yes.
So, all right.
That's the statute we have.
Yeah, that's what we're looking at. I mean...
Yeah, no,
I understand. I mean, look, if we're going to rewrite the law, wouldn't the world be a better place if we just said we're going to stop asking about remedial, procedural, substantive, which are all like incredibly complicated concepts that are impossible to apply objectively, and just say we're going to look at step one for the legislature to say this applies to contracts entered into as of blah, blah, blah date, and then go from there? What would be wrong with that? And then say if it doesn't say that, then we apply it to contracts entered into on or after the effective date of the statute.
If the legislature had a policy of doing that, I suppose we can. I mean, it did do that.
We've already sort of done that for some of these changes, right? The courts have already, I mean, it's this kind of, are we inferring intent or are we imposing this kind of substantive drafting rule on the legislature? I mean. Well,
and if you look, if we're to look at, for instance, it's as part of the same statutory scheme, the assignment of benefits statute, they specifically put the language in that it applies prospectively. If they're going to put the language in every single new statute that exactly what they want, we'd have a lot less discussions in general in many cases. Oftentimes they
good,
don't.
wouldn't it?
But
That would be good, right? Okay,
Well-
well, so take 20 seconds and then we'll hear from the other side.
right, and to make it clear again, we're trying to get, well, we're submitting that we don't need to analyze the legislature here. We just presume. Just for this portion, what's before the court, which was before the 6th District, which was before the trial court here, it's presumed that this statute that applies to lawsuits does not go back to the contract because it does not impact any contractual rights. And really that's what the point we're trying to make. So thank you for the additional time,
Okay,
Your
yeah, and
Honors.
you can have 4 minutes for rebuttal. Go ahead. And we'll make sure that you have as much time, within reason, as much time as you need.
I'd be happy if I didn't need that much. May it please the court, I'm Tom Elliott, and together with my partner Amy Ferrier and our co-counsel, we represent Rebecca Hughes. And I'd like to, of course, we'd like the court to approve the 6th and 2nd and 5th districts on their opinions. I'd like to start with something that we say, but I'm not sure we develop as well as we should have, and that is to the point about what's in the policy. There's no dispute Ms. Hughes complied with all the duties in her 2019 policy. They're set forth at page 69 of the record. She did all that, and she did more. That opened the door. She then had the right to sue under her 2019 policy. Could have sued any time. Claim was partially paid fairly soon after. She sent more stuff in 2020. She kept going, so she didn't get a response, and then she filed suit.
I guess that's as good a point as any to just engage on the core argument about 627-70152 and its operation, the legislature's evident choice to make it operate on all suits as opposed to the policy. And I presume what your argument would be here is that we have to read the whole chapter, but can you respond to the other side's argument that the legislature could have just as easily not made this operate on suits, but instead just have said all policies issued after a certain date have this requirement now?
Your Honor, it doesn't just say all suits. It says all suits, arising under
not even
a, ...
The next words are arising under a residential or commercial property insurance policy.
Exactly. Well, the earlier version we were dealing with had some language in between about assignment, except for assignments, but those are gone now. So yes, it's arising under property insurance policies. And as several judges have noted, that's to distinguish policies involving automobiles, health insurance. You don't do this for those. This is limited to all suits arising under property insurance policies. If the legislature had wanted this to apply to pending suits, they could have said what the Universal's brief says at page 3 of the reply brief: all suits all suits filed after its effective date. They could have put that language in. They didn't. That's the same kind of language. If you look, that would have been similar to the Menendez language that the court said, well, that's clearly retroactive. There are different ways you could have done it to make it retroactive. Simply saying all suits arising, that's telling you the kind of suit. There is no temporal element there.
How would you respond to counsel's, I think her argument, especially at the end, that the rights that are being changed or the obligations that are being changed are only directed at lawsuits? They're not directed at anything in the contract, which is very different than Devin and Menendez and all the cases where there was something within the policy that the statute sought to alter. So how would you respond to that? Because, I mean, it is only talking about a notice requirement for lawsuits, not anything related to a policy.
But that impacts the policy, Your Honor, because as we just said, she did everything she needed to in the policy to file suit. So policies will say, you can't sue us, some are more direct than others, until you do ABC. She did ABC. Under the contract, she has a right to sue then. And now 2 years later, oh, now you've got to do something else.
She has the right to sue, but doesn't the legislature have the constitutional ability to regulate lawsuits once a lawsuit is initiated? In other words, what conduct under the contract is this statute altering?
Well, as we as was talked about earlier, the insurance statutory sections are imported into the contract, not.
So let's talk about that. So statutory is imported into the contract, sometimes explicitly by the legislature. Otherwise, it's because we've created this presumption in Florida case law that a statute in effect at the time of the contract applies to an insurance contract. From my view of that line of precedent, it goes back to kind of a shortcut to the rule that the legislature can't impair obligation of contracts. If we look at this, for example, from the attorney's fees provision, is there any constitutional right to statutory attorney's fees?
Given that the law has long established that the fee statute, when it existed, was a part of the contract.
So outside of PIP cases, do we have any cases that say it's part of the contract?
I'm sorry, what now?
Outside of PIP cases, do we have a
a
statutory attorney's fees is explicitly incorporated?
Yes.
Okay.
The case law, and we've discussed it. I'm sure all the cases we have in our brief are not all PIP cases. There are a number of cases that say the fee provisions are imported into the contract. I mean, Universal needs to import this 70152 into the contract, or it doesn't apply.
But just to be clear, you're being sort of dragged into answering step 2 questions that aren't really that you would only get to if we thought the legislature wanted this new scheme to apply to these policies. Because obviously these questions all go to, assuming the legislature was 100% explicit, we want it to apply to these policies and we don't care what your attorney's fees rights were at the time, this is what we want. We don't care whether you could have sued immediately, this is what we want. That's all step 2.
Yes.
So give us your best argument on step 1.
On step 1, well, we see from cases like Menendez how you could have worded it, and how they worded it, page 3 of their reply brief. Suits filed after its effective date. You could have, that's how you could have done it. It's a variety of ways you could have done it. When you look at what's happening overall, and we look at the whole text, the full 8 provisions, and quite frankly, if we look at the full text of just Section 3, it's not just notice. As Judge Scales pointed out in the Suarez concurrence, you're making the insured go back and adjust their own claim. I mean, it's a lot more duties and burdens on the insured than were ever in the contract. That wasn't in the contract before. Now you're importing these new duties that require them to do that they didn't have to do. So we would say there is no clear intent, which is what's required under step 1 for a retroactive application. And when you read the statute together as a whole, I think Justice Kennedy's point, from 3 you go to 5, which says if you didn't give the notice, you get dismissed. And then that impacts 8 on fees, but it also impacts, again, as Judge Scales noted, you have to go pay another filing fee. You have to go serve them again. I mean, that's hundreds of dollars of fees. That's a penalty. So if we're looking at phase 2, even if we said we're past it and it's intended to be retroactive, and we're in part 2, is there a penalty? And clearly there are penalties here. Clearly. Even putting aside attorney's fees, there are significant penalties. I was glad to hear you say that we're figuring out remedial and procedural and substantive is complicated, because that's what I came to in preparing for this. I do think that the argument that this whole thing was remedial is maybe overstating remedial. And I'm looking at the remedial cases. I'm seeing things like Earnhardt, where they're trying to tweak and fix something, remedy something in a particular statute, not create a whole new statute. So to say the whole new statute.
But if the remedy thing, if we were serious about that, it would swallow up the whole procedural substantive thing, because everything could be characterized in some sense as remedial.
Well, one would, as we said, I think in the brief, one would hope that the legislature is doing things that they hope are remedying or addressing some sort of problem. So yes. So I don't think that saves it. It is clearly beyond procedural, even if we look just at Section 3. I'm glad to answer any other questions, or try to answer them anyway. Then we would ask that you, as I said, approve the 6th 2nd, and 5th. Thank you.
Thanks.
Just to clarify some things, I want to respond first to the question regarding the fees being a part of the contract. There is case law saying that the fees statute, the former fee statute 627-428, is implied in contracts, but we cited to in the reply brief the Petty case from this court, which drew a clear distinction that the implication does not mean it's part of the policy. In that case, FIGA's duties under the statute depended on whether or not that was actually incorporated into the policy, and this court held it is not part of the policy. So I just wanted to answer that question because it goes back to our initial point in that there's no policy right that's being implicated here. Going back to this as far as legislative intent and then step 2, if this is not being applied retroactively, we don't get there. And we contend this is not being applied retroactively. As Judge Boker pointed out in his Carten's decision, all of this comes into play as soon as the rights and obligations under the contract have broken down and it's time for a lawsuit.
Well, yeah, but this is the issue we were exploring with your friend on the other side, that it isn't, it is persuasive at first blush that this particular provision operates on suits. It is clearly the unit on which it operates. But how do you respond to his response, which is that it's clear that this is part of a larger structure, and we're talking about suits arising under residential or commercial property insurance contracts, as opposed to, say, other types of policies like PIP policies or business insurance, and that evinces not that the suit is the operative unit, but that in fact this is a procedural statement about how to effectuate or vindicate your rights under an insurance contract.
The legislature had an ability, as it did in other parts of this insurance reform, to say all suits arising out of contracts that were entered into after the legislation. It didn't. And through and through, it's not just the all suits, it's the as a condition precedent. Again, it doesn't say for all suits arising out of a contract that came into effect after the legislation. Had many opportunities to do this. And so it didn't, and it made, this is a procedural, when you read it through and through, it's not changing any rights. It's not changing the cause of action. So the suits, this is a lawsuit statute which doesn't apply prior to the suit. Outside of that, again, if there's no implication of a right that it's changing, and it doesn't, then it's simply not.
But you say it doesn't. I'm confused by you say it doesn't apply before the suit. It's a prerequisite to the suit. I mean, so the whole predicate is for something that has to be done before suit is filed, right?
That's right. And just to clarify, Your Honor, it's until the right to sue becomes around, when it arises, when the duties and obligations under the policy have broken down.
And you talk about, also, just to shift a little bit here, but you talk a lot about, well, the legislature could have done this, the legislature could have done that. Now, and I understand your argument that this is procedural, and therefore the clear statement rule does not apply, right? That's basically your argument, and which hinges on looking at the notice requirement in isolation. If I understand that, okay, but say we don't buy that. Say we decide it's not procedural, and the clear statement, we're going to look for a clear statement of the legislature that they intend to apply this retroactively. I'm just it's not that they could have done it. I mean, if the clear statement rule comes into play, the legislature has to state it clearly. And this is a venerable rule in this context of when we're considering these issues of retroactivity. That's not something that we just pulled out of a hat recently. That's a venerable rule in our law, in the law of Florida and the law of the United States. And but you're trying to switch it around, it seems like. Now, I understand if it's not, if it is purely procedural, then that's a different thing. But if we get past that, I don't understand how shifting it around like that. You don't need to talk about what the legislature could have done if it is procedural. In terms of the clear statement rule anyway, but I just struggle to see how, when we look at what was said here and this all suits, how that comes anywhere in the range of being a clear statement about the temporal scope of the statute.
And just to make it clear, we're not asking the court to not apply the rule of retroactivity. I mean, if your honors don't agree that this is procedural, then obviously the two-pronged test applies. Two courts have agreed that the language does apply to all suits, that it is a procedural provision that applies. It's a lawsuit statute, and it's a condition precedent to suits, and that this is clear legislative intent to apply it to property damage suits that are filed after the legislation went into effect. The second prong of that, I think it's probably a little circular, but if it in fact is substantive, then we go back to where's the constitutional infringement, and there just is none here. There's not even a vested right that's come into play. So we would submit that the analyses of the third.
But of course, if we disagree with you on the first point, we don't get to the second point. If we think that if we were to think, or majority of us were to think, that that this is not procedural, and that therefore it was incumbent upon the legislature to clearly specify the retroactive impact, then we never get to whether, if applied retroactively, whether it would be unconstitutional or not, right?
Your Honor, that's what Devin says. I agree that's the test.
Well, but that's just kind of common sense. I mean, because we don't decide issues that we don't need to decide. And if we decide they haven't said what they need to say to make it retroactive, then it's not retroactive.
Right. No, that obviously it's not retro. It's if your honors, the majority, disagreed on the first 2 points, then you don't need to get to the second point. Obviously, we contend that first of all, we've had 2 courts agree with our statutory interpretation. We submit that is the proper interpretation, and that this is not governed by Menendez in the sense that we have to go back to the policy and the legislation, and that the first step for the court in determining any application of a statute is to look first at the right that's allegedly being addressed and perhaps infringed upon. And here it just fails that test, it passes that test in a sense that it obviously applies, and no contractual right has yet to be identified or is being impaired in this case. We would ask that your honors quash the 6th district and approve the 3rd and 4th districts in this conflict issue. Thank you.
Okay, thank you very much. We're adjourned for today.
All rise.